Magandang araw po sa inyong lahat at welcome po sa isa na namang video ng Payo ng Abogado. Ang pag-uusapan po natin sa segment na ito ay tungkol sa pagpapatuloy ng mitigating circumstance of minority. Ito po ay handog sa inyo ni Attorney Bernardo M. Loceres. Simulan na po natin. Sa nakaraang module, narito ang highlights na ating pinag-usapan. The basic reason recognizing exempting circumstance, acted with discernment, intent, and discernment are two different concepts. Let's continue. Mitigating circumstance of minority, number 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Accident is an exempting circumstance under Article 12 of the Revised Penal Code. In order that an accident may exempt an accused from criminal liability, it must be shown that the accused was performing a lawful act with due care. The resulting injury was caused by mere accident, and there must be no fault or intent to cause the injury on the part of the accused. Exemption from criminal liability proceeds from a finding that the harm to the victim was not due to the fault or negligence of the accused, but to circumstances that could not have been foreseen or controlled. Thus, in determining whether an accident attended the incident, courts must take into account the dual standards of lack of intent to kill and absence of fault or negligence. Police officer tried to defend his possession of the weapon when the victim suddenly tried to remove it from his holster. Again, it was in the lawful performance of his duty as a law enforcer that petitioner tried to defend his possession of the weapon when the victim suddenly tried to remove it from his holster. As an enforcer of the law, petitioner was duty-bound to prevent the snatching of his service weapon by anyone, especially by a detained person in his custody. Such weapon was likely to be used to facilitate escape and to kill or maim injury persons in the vicinity, including petitioner himself. Petitioner cannot be faulted for negligence. He exercised all the necessary precautions to prevent his service weapon from causing accidental harm to others. As he so assiduously maintained, he had kept his service gun locked when he left his house. He kept it inside its holster at all times, especially within the premises of his working area. Wherefore, the petitioner is acquitted of the crime of homicide. Number 5. Any person who acts under the compulsion of irresistible force. A person who acts under the compulsion of an irresistible force, like the one who acts under the impulse or uncontrollable fear of equal or greater injury, is exempt from criminal liability because he does not act with freedom. The force must be irresistible to reduce him to a mere instrument who acts not only without will but against his will. The duress, force, fear, or intimidation must be present, imminent, and impending, and of such a nature as to induce a well-grounded apprehension of death, of serious bodily harm, if the act is not done. A threat of future injury is not enough. The compulsion must be of such a character as to leave no opportunity to the accused for escape or self-defense in equal combat. Illustration. A is armed with .45 caliber pistol. A instructed B to stab X on the stomach. B did not follow the instruction, hence A slapped B using the pistol. Thereafter, A instructed B to stab X with a warning from A that the latter would shot B's head if X was not stabbed by B. Then B stabbed X. B was freed by A. In this illustration, B can be exempted from criminal liability because he acts under the compulsion of an irresistible force and he did not act with freedom. Duress, force, fear, or intimidation to be available as a defense must be present, imminent, and impending. Duress, force, fear, or intimidation to be available as a defense must be present, imminent, and impending, and of such a nature as to induce a well-grounded apprehension of death or serious bodily harm if the act is not done. A threat of future injury is not enough. To be available as a defense, the fear must be well-founded and immediate, and actual danger of death or great bodily harm must be present, and the compulsion must be of such a character as to leave no opportunity to accused for escape or self-defense in equal combat. It would be a most dangerous rule if a defendant could shield himself from prosecution for crime by merely setting up a fear from or because of a threat of a third person. Fear as an excuse for crime has never been received by the law. No man, from fear or circumstances to himself, has the right to make himself a party to committing mischief upon mankind. Number 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. A person is exempt from criminal liability if he acts under the compulsion of an irresistible force or under the impulse of an uncontrollable fear of equal or greater injury, because such person does not act with freedom. However, we held that for such a defense to prosper, the duress, force, fear, or intimidation must be present, imminent, and impending, and of such nature as to induce a well-grounded apprehension of death or serious bodily harm if the act be done. A threat of future injury is not enough. The appellant, however, on this entitled case was convicted by the trial court and affirmed by the Honorable Supreme Court. Number 7. Any person who fails to perform an act required by law when prevented by some lawful, insuperable cause. This situation in number 7 was applied in the case of the people of the Philippines versus Josefina Bandian. The accused was convicted by the trial court of the crime of infanticide but exonerated by the Honorable Supreme Court on the ground of number 4 and 7 of Article 12 of the Revised Penal Code. The facts of the case are: at about 7 o'clock in the morning of January 31, 1936, Valentin Aguilar, the appellant's neighbor, saw the appellant to go to a thicket about 4 or 5 brazas from her house, apparently to respond to a call of nature because it was there that the people of the place used to go for that purpose. A few minutes later, he again saw her emerge from the thicket with her clothes stained with blood both in front and back, staggering and visibly showing signs of not being able to support herself. He ran to her aid and, having noted that she was very weak and dizzy, he supported and helped her go up to her house and placed her in her own bed. Upon being asked before Aguilar brought her to her house what happened to her, the appellant merely answered that she was very dizzy. Not wishing to be alone with the appellant in such circumstances, Valentin Aguilar called Adriano Comcom, who lived nearby, to help them, and later requested him to take bamboo leaves to stop the hemorrhage which had come upon the appellant. Comcom had scarcely gone about 5 brazas when he saw the body of a newborn baby near a path adjoining the thicket where the appellant had gone a few moments before. Comcom informed Aguilar of it and later told him to bring the baby to the appellant's house. Upon being asked whether the baby, which had just been shown to her, was hers or not, the appellant answered in the affirmative. Ruling. The Honorable Supreme Court ruled as follows. The act performed by the appellant in the morning in question by going into the thicket, according to her, to respond to call of nature, notwithstanding the fact that she had fever for a long time, was perfectly lawful. If by doing so she caused a wrong, as that of giving birth to her child in the same place and later abandoning it, not because of imprudence or any other reason than that she was overcome by strong dizziness and extreme debility, she could not be blamed, therefore, because it all happened by mere accident. From liability, any person who so acts and behaves under such circumstances. By the way, it should be stated that there is no evidence showing how the child in question died. Dr. Nepomuceno himself affirmed that the wounds found in the body of the child were not caused by the hand of man, but by bites animals, the pigs that usually roam through the thicket where it was found. The evidence certainly does not show that the appellant, in causing her child's death in one way or another, or in abandoning it in the thicket, did so willfully, consciously, or imprudently. She had no cause to kill or abandon it, to expose it to death. The appellant's extreme debility, undoubtedly caused by her long illness as well as the hemorrhage which she had upon giving birth, coupled with the circumstances that she is a primipara, a woman who is giving birth for the first time, being then only 23 years of age and therefore inexperienced as to childbirth, and as to the inconvenience or difficulties usually attending such event, undoubtedly were the reasons why she was not aware of her childbirth, or if she was, it did not occur to her, or she was unable due to her debility or dizziness, which causes may be considered lawful or insuperable to constitute the seventh exempting circumstance. In conclusion, taking into account the foregoing facts and considerations and granting that the appellant was aware of her involuntary childbirth in the thicket and that she later failed to take her child therefrom, having been so prevented by reason of causes entirely independent of her will, it should be held that the alleged errors attributed to the lower court by the appellant are true, and it appearing that under such circumstances, said appellant has the fourth and seventh exempting circumstances in her favor, is hereby acquitted of the crime of which she had been accused. Thank you very much for finishing this module.